Welcome back. You're watching Your World at 10. Now, it's India's most fiercely fought corporate battle, and it could reach a conclusion very, very soon, as the Chief Justice of India, KG Balakrishnan, will retire in May. So on tonight's show, we revisit some of the arguments by Reliance Industries, RNRL and the Government of India in the fight for gas. Joining us to take us through the various arguments are Supreme Court advocates HP Ranina and Gopal Jain. Gentlemen, thank you very much for joining me. The two core issues at heart here are whether gas, which is a national resource, can be allocated by virtue of a private agreement, and what is the sanctity of a private agreement. Mr. Ranina, which issue will weigh heavier based on the arguments that we have heard?
I think the first thing which the Supreme Court will do is to consider this aspect, whether the natural resource belonging to the government can be the subject matter of a private contract or not. Now, this is a very important issue because this will have a bearing on various other issues involved where natural resources have to be taken into account. So I think the first point which the Honorable Supreme Court will decide is on this issue, whether a natural resource can be the subject matter of a private contract. And if it is the subject matter of a private contract, then obviously the contract will prevail.
Gopal, interestingly, the two conflict, right? Because you've got to protect the sanctity of a contract, and yet, as Mr. Ranina pointed out, gas is a national resource, and therefore you've got to protect the government's jurisdiction over allocation of gas as well. So how do you manage to balance both without hurting the interests of any one cause?
So it's a question of drawing the line correctly. As Mr. Ranina rightly said, there is a larger issue which is a public interest issue, which is the question of who's the owner of the resource, and obviously policy is made on these aspects. So let's take another example. You take spectrum in the telecom sector. It's a valuable natural resource. It's a scarce resource. The Government of India makes policy for allocation and charging. No two private parties can enter into a private contract on its allocation or its pricing. So that's the first point to be noted, that if something lies in the domain of the government, that is a matter of policy, then it cannot form a part of the contract.
But Gopal, if I may interrupt you there, if that is the decision, then in that sense that does compromise the contract between the two parties, doesn't it?
Yeah, Menaka, I'm just coming to it.
Okay.
So in all these sectors, you have to look at it in three different spheres. There's the aspect of policy, there's the aspect of contract, and there's a policy of regulation or guidelines, you know, whatever the case may be. The question, like with the Constitution, separation of powers, you have the judiciary, you have the executive, you have the legislature, there's a separation of powers. Equally, therefore, there has to be a division along these lines. So if two people decide to include, let us say, a public road which runs alongside their house into an agreement, they can't say, look, there's a sanctity of contract, so you can't go into it. So if a contract impinges on an area of policy or into another area which is not really the subject matter of a private contract, then to that extent the contract is incorrect. I'm just giving in general the principle. So we have to apply this principle, which would also apply in this case, which is you first decide what is a resource, in which domain it lies. If it lies in the public domain, it cannot form a part of a contract. To that extent, therefore, it would be incorrect. So you can't always couch something under the guise of sanctity of contracts, but courts usually, as a matter of principle, do lean in favor of contracts. But it does not exclude courts from looking at the legality of a contract.
But Gopal, this is the short answer to that could potentially be that if you're going to rule that gas allocation is a matter of national issue, then does that mean a redrawing of contract? And if it does mean a redrawing of contract, then what are we ending up with? More litigation?
No, I think if the court draws a line and lays down the principle, then I think going forward it will reduce litigation. And just out of interest, it's not that the courts cannot examine contracts. In fact, they can. In a recent judgment of a constitution bench of the Supreme Court, in the case of PTC, Power Trading Corporation versus CRC, the courts have in fact said they can go and examine contracts and strike them down as well. So you have to look at these concepts in a dynamic situation, in changing times, as I said. attempt should be to have convergence between policy, contract and regulation. But if they pull in different directions, like an umpire, the court always steps in, and it's for the court to draw the lines correctly.
Oh, absolutely. So we're waiting for the court to draw that line. Now, Mr. Ranina, do you think that the final outcome could possibly include a direction towards redrawing the contract of some sense? And if that's the likelihood, then what are we staring, or what are we looking at in terms of a final settlement between these two warring parties?
Well, Menka, if you will recall, the Bombay High Court itself had indicated that it would be a good idea for the two brothers to come together and take the advice of their mother, take the help of their mother, and maybe revise the contract. So maybe they had this possibility in mind, that if for any reason it is held that this is part of public policy which cannot be the subject matter of a private contract, then the private contract will have to be mutually drawn up. And therefore, they had suggested that the mother should intervene and make sure that there's an equitable and fair distribution of whatever assets remain. So drawing up of a contract, redrawing, I think, is already on the cards.
In fact, if they do end up asking for redrawing of the contract, and I'm not trying to presume the Supreme Court ruling here, but that would in fact balance both interest cases, right? So they're holding in favor of gas being a national asset. They're also saying that the contract as is, we're upholding the sanctity of the contract, except that you can't include gas in it, and therefore you need to redraw the contract. Is that a fair, sort of understanding of how they might choose to balance both interests, Mr. Ranina?
Well, it's difficult to speculate as to what the Honorable Supreme Court will ultimately decide, but this is one possibility, certainly. And this is why I indicated even the Bombay High Court had made such a suggestion. Therefore, redrawing the contract on the ground that the two parties were aware of what are the issues, what are the assets, what are the liabilities, and therefore they are the best persons to sit together and once again redraw their arrangement so that there's a fair and equitable distribution of assets, which was earlier contemplated in 2005 when the contract was drawn up.
Gopal, in your assessment, based on all the legal precedents we have facing us, if at all in this case, do you think that the likely outcome could be a direction to redraw the contract?
Well, I wouldn't want to second guess or speculate on what the outcome could be, but yes, courts usually do perform a balancing act, and they usually try and see how they can reconcile what looks as seemingly two inconsistent or contradictory positions. And I think it's as important to ensure that policy is followed as scrupulously as contracts, because as you know, in infrastructure sector, certainty is very important. And certainty comes from clarity, clarity comes from what is stated in the policy. So giving full weight to policy and ensuring it's if I may say so, executed and implemented in letter and spirit is as important as respecting contracts, and therefore I think courts will balance the two to make sure that both can coexist to the extent the court can.
All right, Mr. Ranina, the one final issue that I want to bring you in is on the fact that we're also waiting for this judgment because it will be precedent setting to explain to us whether, an agreement like this between the head of a company and some member of his family is binding on his company or not, right? The High Court has already ruled that it is binding, but we may have a completely different precedent based on what the Supreme Court rules, and that will be watched very closely by corporate India. It is an important point, right?
Yes, absolutely. And I think whatever decision comes will be in the context in which the demerger has already taken place. Because obviously the very fact that there is a demerger of certain assets from the main company itself indicates that the company was bound by some type of an agreement. Therefore, the court will give cognizance to the fact that this has actually happened, and therefore they should go forward in a very logical manner and make sure that everything is done in an equitable and fair manner.
Maybe I'm getting a little ahead of myself, Mr. Ranina, but if there is a redrawing of contract that is to be determined as the next step, but some part of that contract has already been borne out, as you pointed out, through the various demergers that took place, this could continue to be a pretty messy legal space.
I agree with you. It will be, because none of us are aware of the real value of the assets which the family owns, and therefore there will be a certain amount of redrawing. Maybe it may be very bitter, but that is something which they'll have to sort out within closed doors. and I don't think anybody has any access to it, except perhaps Mr. Kamath, who was at one stage instrumental in drawing up that agreement.
Absolutely. Gopal, your last thoughts on what you're expecting as important takeaways from this Supreme Court judgment when it comes?
I think the important takeaway would be the principles which the court will establish. And like I said, this will apply across the infrastructure sector. So you can either have policy coexist with contract, or if there's a public interest component in the contract and the court feels that, look, that has greater weightage or it has larger implications, then they could say to that extent, we uphold the public interest material resource owned by government. No two parties can, enter into a contract which impinges upon or transgresses into any area of public interest or, ownership, etc. So they could, as I said, lay down principles, draw the lines, and there would be much greater clarity and certainty for all parties going forward, not just in the oil and gas sector, but in other sectors as well.
Gentlemen, thank you so much for refreshing the issue. We're now counting down days to this very crucial Supreme Court judgment. Mr. Ranina, Gopal, thank you very much for your time.